25 at 1:30 p.m. Eastern Time, 12:30 Central Time. This is three-judge panel hearing case number 25 CV 0225, a Washington County Chancery case styled Ralph Thomas Reach, MD versus Tennessee Board of Medical Examiners. The three judges assigned to this case are Judge Deanna Bell Johnson of the 21st Judicial District, Judge A. Blake Neal of the 25th Judicial District, and I am Chancellor John Rambo of the 1st Judicial District in Washington County, the home county for this cause of action. We're here on summary judgment motions filed by the plaintiff petitioner and the Tennessee Board of Medical Examiners, the respondent defendant. We will proceed with some basic ground rules. Each party is given 30 minutes to argue both summary judgment motions. That's 30 minutes total, not 30 minutes for each one. A lot of the arguments overlap. If you want to reserve some rebuttal time, you need to tell me that before you get too far along in your argument when you start. So having said that, who do we have on our Zoom hearing for the petitioner appellant?
Your Honor, I am C.J. Gideon. I represent Dr. Tom Reach, who is also here on the Zoom. In the room with me is Dr. Reed Finlayson, who is an interested party.
And you'll be handling the argument today?
Yes, sir, I will. And I'd like to reserve 5 minutes to respond, if need be, to what is said by the state.
Sure. And who do we have for the state?
Ryan Gallagher here on behalf of the state, along with my co-counsel, Sarah Sedgwick and Rachel Appelt.
All right. Thank you. All right, we'll start the clock now, and petitioner, you may proceed.
I think it'll be the most efficient use of our time if I can outline for you at the outset the 7 points I intend to make today. First, I want to address the elements of the petition that are not in dispute in this summary judgment proceeding. Secondly, Dr. Reach's right to due process. Third, how much due process is due, and under that heading, the risk of erroneous deprivation and how that actually occurred in this case. Fourth, I will distinguish the cases the state relied on. Fifth, I will address the issue of substantive due process and the vagueness of the statute. Sixth, the value of a hearing. And seventh, I'll close. And I hope to do so within 20 minutes. Let me start off by addressing the petition. Share it. These are the points that are not in dispute, Your Honor. Dr. Reach, licensed to practice medicine in Tennessee since 2006. On June 30th, 2023, the Board of Medical Examiners mailed him a letter that automatically and summarily revoked his license pursuant to TCA 63-1-170 immediately, with no hearing before or after that act and no opportunity to apply for reinstatement. He received no communications from the board before the June 30th letter. They didn't provide him any notice that it was coming, and they did not give him a hearing of any kind, small or large, before the revocation of his license that he'd held for 17 years in the state before that time. He is aggrieved because, and we've laid this out in this petition that was filed in February of 2024, aggrieved by the denial of due process under both the state and federal constitution. We contend respectfully that TCA 63-1-170 is both facially unconstitutional and unconstitutional as applied to Tom Reach. We respectfully contend that this whole process has violated statutory provisions, most specifically 63-6-16 and 4-5-320. We insist respectfully that it was an unlawful process, and we point out to you, and it's not disputed, that he has exhausted his administrative remedies. We took this before the Board of Medical Examiners, asked them to strike down the statute, which we didn't think they would. They didn't, and they denied our petition for a declaratory order January 23, 2024. What's the relief we ask for today? We ask you to reverse this decision by the Board of Medical Examiners to take away Tom Reach's license. We ask you to make a declaration that this statute is unconstitutional, and we ask you for an award of costs, expenses, and reasonable attorney's fees under the Tennessee Equal Access to Justice Act and that specific provision of the Administrative Code 4-5-325. Right to due process. There's not really any issue, given the holding in Bell versus Burson, that once you have a license issued by the state, you have a right to due process, and it cannot be taken away unless you comply with the requirements of the 14th Amendment. It was. So the next issue then becomes, well, what process is required? And this case remains the leading decision in the United States, Matthews versus Eldridge, on the important issue of what process is actually required. And the inquiry in that opinion was, first of all, how important is the interest? And I don't think there's any dispute between myself or Mr. Gallagher. This is an interest of profound importance. Secondly, what's the risk of erroneous departure from reasonable standards, the risk of erroneous deprivation if there is no hearing? And I'm going to demonstrate to you that there's not only a huge risk, but one that became a reality in this case. And then the last issue is, what are the fiscal and administrative burdens if you have a hearing? They're non-existent. The Board of Medical Examiners meets every 60 days in the state of Tennessee, and here's a score of cases. There's no dispute about that. So let's look at the basis for the action by the state against Tom Reach. Come back to that later. Here's what he pled guilty to, members of the court. And I've highlighted it because I asked you to look at it fairly carefully. He pled guilty to causing drugs to be misbranded while held for sale after shipment. And you can see the federal USC citations that he pled guilty to. And this is page 1 of the stipulated administrative record. From page 5 of the stipulated administrative record, you will find this document that's before you now. Again, plea of guilty to causing drugs to be misbranded while held after sale after shipment. 3 pleas, 3 misdemeanors under the federal law. Let me show you the statute that is the basis for the plea. And here it is. Now, why am I spending limited time to address this? I wanted you to see the statute rather than relying upon me, because application of this statute is not limited to, nor does it require that the drug be a controlled substance. And that's important. This statute that he pled guilty to is a federal statute that deals with misbranding any drug. Same thing is true of the other statute that he pled guilty to, and I've highlighted it for you. There is nothing in that plea that establishes that he pled guilty to misuse, misapplication of a controlled substance. Likewise, there's nothing in the plea that establishes anything dealing with sexual misconduct by a physician. And I will mention something that I know the members of the court know, and that is all drugs requiring prescriptions are not controlled substances, both under state and federal law. So let me show you the statute that led to the automatic summary denial of a license that this gentleman had held for 17 years. And this is the statute we challenge on several grounds. But here it is. If somebody pleads guilty, to a federal or state criminal offense that involves a controlled substance or sexual offense, their license is toast. It's finished. When did this become effective? To avoid any argument about its effective date, it became effective when it was approved May 18th, 2021. And it was effective in terms of its consequences at that time. You will recall, looking back, that Tom Reach's pleas all involve conduct that preceded the effective date of this act by years. I represented to the members of the panel that the risk of erroneous deprivation of the license was high, and it is. And that's an element that deals with the extent to which more due process is required. And I want to show you two orders from the Board of Medical Examiners. One is the Yang order, which is attached to part of our motion for summary judgment. And I will highlight the sections of the Yang order that are material. Here's what he was charged with: knowingly and willfully writing a patient a prescription for oxycodone, no dispute, controlled substance, subsequently pleading guilty in the Eastern District of Tennessee in October of 2017. He was convicted. The state recited how they were quite aware of that conviction. They reprimanded his license. His license was subject to the same statute. He is a physician practicing in Tennessee. He pled guilty to a crime involving a controlled substance, and he retained his license from the defendant. That's not fair.
Mr. Gideon.
Yes.
Judge Neal here. Was Mr. Yang's, was his action by the board not taken before this statute was effective?
No, sir, I don't think so, because I'll show you the date.
But his guilty plea was before the statute was effective, right?
Yes, just as Tom Reach's was, but here is the effective date, Judge Neal, for the action by the board, July 25, 2023.
But what I'm saying, when Dr. Yang pled guilty to the underlying federal offense, that was before the effective date of this statute, whereas
yes, sir.
When Dr. Reach pled guilty, it was after the effective date of the statute.
Yes, sir, you are correct, but I will remind you of the effective date language of the statute, which says it applies if the board becomes aware of an action after the effective date of this. So the fact that he pled guilty beforehand, I respectfully submit, does not matter.
Okay, thank you.
Secondly, that's not just one errant example. And I must tell you, I appear before the Board of Medical Examiners on a regular basis. These are good people. They're not intentionally trying to discriminate against Tom Reed. But here is yet another example, and this is the Rudin case, where the pleadings are full of references to controlled substances. Action taken against his license because of improper conduct with respect to controlled substances. He pled guilty. Probation. And given Judge Neal's comments, I want to show the effective date of the order, May 16th, 2023, after the effective date of the statute. So my point here is not to say that they were treated correctly or wrong. My point is that one of the elements in deciding how much due process is due is the risk of an erroneous action. And I've demonstrated here that Tom Reed had his license yanked. These others maintained their licenses. I think any fair-minded individual would agree that in this set of circumstances, the risk of erroneous deprivation has certainly been shown to be a reality. Next, what I'd like to do is distinguish some cases, and I just throw these out because I think they're...
Mr. Gideon, I hate to interrupt, but can I ask a question?
Of course you can.
what if this statute, the one we're dealing with here, 63-1-170B, what if it specifically listed the federal crime for which your client pled guilty? I mean, what if it read a healthcare prescriber convicted of, and listed out that federal statute that he pled guilty of, and along with other statutes? What would that do to your argument at that point?
Well, it would certainly impair the argument that I intend to make, which is the statute's not sufficiently specific. And it would impair the argument about vagueness if that's all it said, and said, for example, if you violate 28 USC 331K, we will take away your license.
But what about erroneous deprivation in due process? Would your argument still be that he would be entitled to a hearing if the statute specifically listed it? Yes,
it would.
And why is that?
Because this particular property right is a property right that is entitled to the protection provided by a hearing either before or after the action is taken.
So what about, what if he was convicted in Tennessee state court of delivery of a controlled substance, Schedule 2 fentanyl, in an amount of 26 grams or more, which is a B felony in our state? What if he had pled guilty to that? Would he still be entitled to a hearing?
I have to say yes, because I think that the interest being protected is so important that he should have a hearing to make sure, for example, that he did indeed plead guilty, that in fact he is the individual who pled guilty. But it wouldn't have to be much of a hearing at all. He would have a notice that the Board of Medical Examiners was going to take action against his license and proposed to revoke his license based on that conviction. And then the Board of Medical Examiners could revoke that license. They could do it summarily if he was a threat to the public. But Judge Neal, I'm having some difficulty maintaining an argument on what exists now as compared to the potential if the statute was more specific, because one of the arguments is that it is so non-specific that it will capture so many things that will lead to revocation that it's unconstitutional.
No, I understand that. I guess one of the things when I've been reading the case law on this issue is both with the vagueness issue and the due process issue that we have to look at it specifically in your client's case to see if it's void for vagueness or to see if it violates his due process rights. Not
correct.
Now, I know in the due process you're making it a facial challenge, and so that's why I'm asking you these questions about these specific crimes. And so it has to do with sexual violations too. So your argument is that if your client pled guilty to aggravated rape of a child, he would still be entitled to a hearing. That there's no way the state could use this statute to revoke a medical license for that type of conviction.
Well, yes, but the knowing how things work, 63-6216 already gives the state of Tennessee Board of Medical Examiners the authority to take away a license for somebody who's pled guilty to or been convicted of a felony. If, for example, the scenario you described occurred, the Board of Medical Examiners would summarily suspend the license if it was a physician who had raped a child. No question. There'd be no threat to the public. That individual would lose his license. That individual, faced with a notice of charges, wouldn't have a leg to stand on at all.
Okay. All right. Thank you.
You're most welcome. Let me just distinguish a few cases, though, before I get to points that I think will raise some additional questions from Judge Neal. Crum versus Vincent, the 2007 opinion from the 8th Circuit that the state relies on heavily in their brief. That's a case where a physician had his license revoked for failing to file tax returns in 2000, 2001, and 2002. The state sent Dr. Crum a notice telling him, if you don't file your tax returns, you're going to have your license revoked. Notices of tax deficiency were sent to him They told him in those notices he could request a hearing. He did not request a hearing. His license was revoked. He then paid his taxes and his license was reinstated. He was offered a meaningful opportunity to be heard and he ignored it. That case does not support the state. The state relies on Crack versus Garvey, a 2003 decision of the Sixth Circuit. After extensive interaction with the FAA, this individual obtained a post-revocation hearing upon his appeal to the NTSB, and they had the authority to affirm or reverse the loss of his pilot's license. Valero is yet another case with the very same comments, and that is there were very specific grounds for revocation of a license. He was given advance notice of the plan for revocation. He was given an opportunity to challenge, which is pertinent here, and he ignored it. And finally, in the cases relied upon by the state, I want to bring to everyone's attention Hawker versus New York, the 1898 opinion by the United States Supreme Court, giving that some context. That was 22 years before the 19th Amendment, before my politically active wife was authorized to vote. And as you read the opinion, and I've read it over and over and over again, I can't tell if the physician was previously licensed, had his license revoked, and then started doing abortions, or if he was licensed and performed abortions, which were illegal at the time. But I cannot tell from reading the opinion which of those two scenarios apply, and I suggest to the court that it's not very meaningful in terms of guiding your decision. Let me address vagueness. Go ahead, George. Chancellor Rambo, how much time have I used?
Can't hear.
Cannot hear you, Chancellor.
Sorry. You've used 20 minutes, but I'm going to extend it 10. You've had several questions from judges, so we'll give you a little more time.
All right, thank you. I want to address vagueness because I think this deals very specifically with the specificity question raised by Judge Neal. We don't have to go out of state to find case law on vagueness. Supreme Court of Tennessee, 2005, in the modern era. A statute is unconstitutionally vague if it does not serve sufficient notice of what's prohibited, forcing men of common intelligence to necessarily guess at its meaning. I want to show, and I'm not just responding to Judge Neal's questions, but I think these examples are real world examples why the vagueness of this statute is so dangerous. I'm going to recite for you some specific statutes that physicians deal with every day. Violation of any one of these statutes would lead to summary loss of license. Here's one. Let's say you have a physician who has a prescription for alprazolam or Xanax and makes the mistake of driving. That is a controlled substance. Now that physician should absolutely lose his driving privileges, be punished for driving inappropriately, but he shouldn't lose his license. However, violation of this statute involves a controlled substance. And Judge Neal might well say, well, you found one example, but how many are there really? There are a bunch. Here's another one. One of the things that's wonderful about controlling opioid misuse in the state is the CSMD that one or more of you may have dealt with before. But when a patient comes into the office and says, hi, I've got back pain, it allows you to check and see if that patient is getting controlled substances from somebody else. Very easy, very quick, very well done. If you don't check the database, you have violated this specific statute, which involves a controlled substance. And I'm not finished. Here's another. If somebody comes into the office and says, I've got really bad back pain, I need some OxyContin, and you can tell that they're con artists, they're attempting to get drugs illicitly, you have an obligation as a physician to report that. If you do not, it involves a controlled substance, you could lose your license. Here's another. If you dispense a controlled substance, and inquiring mind might say, how often is that? Well, the common drug for weight loss is phentermine. It is commonly dispensed. It is a Schedule IV drug. If you are dispensing medications at your offices, you have to have separate registration at each of the offices. So if you've got a weight loss program in Jonesboro and you've got one in Johnson City and one in Bristol, you have to have each of these offices registered. If you don't, that involves a controlled substance, and it gives that statute a basis to take away your license. Here's one that comes up all the time. PAs and nurse practitioners have expanded the delivery of healthcare substantially in the state. But one of the requirements is that if you are going to utilize a PA or a nurse practitioner, you have to have jointly authored written protocols, especially those that deal with the prescription of controlled substances. Let's say you make a mistake and you, A, don't have a protocol that is sufficient, and that PA prescribes Percocet and it's not authorized, or the PA ignores the protocol. This involves a controlled substance, can lead to the loss of the license under the literal application of that statute. And I don't think that was ever the intention of the legislature.
Mr. Gideon, before you move,
Yes, sir.
on to the next point on the vagueness doctrine, because my understanding of the law is one of the things you have to look at before striking down, because I'm inclined to agree with you that the statute is vague. But the case law says that a plaintiff who engages in some conduct that is clearly prescribed cannot complain of the vagueness of the law as applied to the conduct of others. And that's from Village of Hoffman Estates versus Flipside, U.S. Supreme Court opinion. And then from a Tennessee opinion, the standard is vague in a general sense, but it's also necessary to examine the statute to see whether it is vague as applied to the affected party. And so I guess my question for you is Dr. Reach's conviction of the type that the statute was aimed at, because of the title of the statute and what it involved?
I respectfully submit the answer to that is no. And that's why I took some of the limited time to show you the actual plea, Judge Neal, the plea to inventory management and labeling, but it doesn't have anything to do with controlled substance. And Tom Reach is a bright man. He was represented by counsel in that proceeding, but I respectfully submit that statute does not give you notice that if you pled guilty to inventory problems in the federal court in Virginia, you would lose your license in Tennessee. And this leads to the last point. And I thank you for the time, Chancellor Rambo. The value of a hearing in this case, recognizing that no one disputes the Board of Medical Examiners will be meeting regularly with a full docket, 2-day hearing every 60 days. So we're not talking about asking the state to spend additional money in any material fashion. But the value of a hearing would be pretty simple, and that would be, did Tom Reach plead to a violation of a controlled substance law? Number two, is there a nexus between what he pled to and his character, his fitness to practice, and risk to the public? And third, in this case, I would respectfully submit, Judge Neal, the question is, how is he different than Dr. Yang and Dr. Rudin? What have we done here? Why do we have such a different treatment of three similarly situated individuals? And I'd like to close now with a final point, and that is the judiciary, the federal judiciary, has gotten a lot of attention recently with decisive action by the Trump administration. And one of the things that is troubling to me as a citizen and as a lawyer is the fact that Tom Reach got less process than a Venezuelan illegal immigrant in the country illegally accused of crimes. And this is the opinion from the United States Supreme Court, recognizing that even these members of Tres Argua, or however you pronounce it, are entitled to a hearing. This is an opinion by the current Supreme Court. And I throw this out, Judge Neal, I know you're not going to ask me, does this apply? I don't think it applies directly, but it does reflect how important due process is in our country. And I respectfully submit to the panel that what should occur in this case is that this case should lead to a determination that this statute is unconstitutional as applied to Tom Reach. That Tom Reach was entitled to a hearing either before or after that action, and is entitled now to what he should have received 2.5 years ago. And unless there are some additional questions, I close, Chancellor Rambo, and thank you for the time.
I have a question. Would an option for the panel be to remand it back to the board with directions to give sufficient due process hearing under the law, notice and hearing?
I don't know. I honestly don't. I don't know the answer to the question.
All right.
And the reason I say that, the statute itself demands and requires a single remedy in the event of application. So because of that, I'm not being evasive. I just don't want to make a misrepresentation to a member of the judiciary.
Well, basic due process could be, are you the same person who pled guilty to this in that state? Or was it a controlled substance or a tobacco product that triggered the plea under that statute? I mean, just basic stuff that you could clear up a misunderstanding.
Right. And as you point out, at a hearing, either before or after, there could be additional questions about, well, what did you plead guilty to and why? Number two, what does this say to us about your character and your fitness to practice medicine in your community? Some additional inquiries could be made. Those have never been made.
Thank you.
Thank you.
Mr. Gideon, following up on that, if we found the statute unconstitutional, at that point, would we remand it to the board to conduct their usual procedures for when disciplining a doctor?
Whether this panel would formally remand, or the Board of Medical Examiners would recognize that they needed to set aside their action because the statute itself was unconstitutional, the end result, I think, is the same. Tom does not walk free, but he goes back before the Board of Medical Examiners for them to make an informed decision about what to do with him.
Okay. All right.
I have a couple of follow-up questions, Chancellor Rambo, if that's okay.
Proceed.
So, Mr. Gideon, kind of following up on what Chancellor Rambo was asking you about, and to some extent, Judge Neal, your client doesn't claim that was not him who pled guilty in Virginia or whatever state it was, or that he just was working with a tobacco product. There's no kind of allegation like that by your client, correct?
No, ma'am.
Okay, and then another question I have is, when did Dr. Rudin plead guilty vis-a-vis the effective date of the statute? Did he plead guilty before the statute became effective?
I'm gonna have to pull that slide back up. George, can you pull that up, please? Was your question as to Dr. Rudin?
Yes, sir.
Okay.
I understand that Dr. Yang pled guilty before the effective date of the statute, but you didn't tell us when. I see this agreed order is after the statute, but when did he actually plead guilty?
Okay. March 13th, 2023, paragraph 8. That's up on the screen right now.
All right, thank you.
Yes. Do you have any additional questions, Judge?
I do. Did your client, Dr. Reach, know at the time he entered his guilty plea about this statute and that his license would be summarily revoked?
No.
All right, thank you. I have no other questions, Chancellor Rambo.
Thank you. All right. Let's hear from the Board of Medical Examiners.
Good afternoon, and may it please the court. My name is Ryan Gallagher. I'm here on behalf of the Board of Medical Examiners. I'd like to start by clarifying the issues that are actually before this court. On pages 3 and 4 of petitioner's memorandum in support of his motion for summary judgment, he lists 9 separate claims. Only 2 of those claims are actually before this court. The 2 claims are the procedural due process challenge, facially and as applied. The other 7 claims are not properly before this court. So numbers 1 and 2, the arbitrary and capricious challenge, that's essentially a substantive due process challenge. That is not included in the petition. Argument 8 and 9 as well. Argument 8 is the unsupported by evidence challenge. That is not included in the petition. So that is not before this court. In the argument 9, that 63-170 is unconstitutionally vague, that is also not alleged in the petition. So he's not entitled to summary judgment on any of those claims that he didn't put in his petition.
Mr.
And
Gallagher, question, because I mean, when you raised that in your motion, I started looking at the petition, but then he also filed a Supreme Court Rule 54 notice, which specifically lists vagueness. In the Supreme Court Rule 54 notice, the rules say that he has to list the issues that he's challenging or the grounds for challenging. So would that make any difference to your argument that it's not included?
No, Judge. I believe it would still have to be included in his petition, and there's 2 things I would cite. The first would be Rule 5604, the summary judgment rule, which includes the pleadings. The pleadings are part of what guides the motion for summary judgment. And the next thing I would point to is Rawlings versus John Hancock Mutual Life Insurance, which is a Tennessee Supreme Court decision from 2001. And there the court said, unless the unpled claim has been tried by consent in the trial court, it cannot provide a basis for judgment in favor of the claimant. And obviously, these claims that were not alleged have not been tried by consent. We objected to those in our response to the fact that they weren't included in the petition. The other category of claims that are not properly before the court are all the claims that he brings under 45322. 45322 is the judicial review statute. This is not a judicial review case. So any of the claims that cite 45322 as the basis are not properly before the court. Those would be claim number 5, that the revocation violated other statutory provisions. Claim number 6, that there's other statutory provisions requiring independent evaluation. And claim numbers 7 and 8 also come under the UAPA. So anytime he cites 45322, those claims, this court does not have subject matter jurisdiction over those claims because there was no contested case proceeding. So the only 2 issues before the court are the procedural due process claims. And he alleges both a facial and an as-applied challenge, but it's really just a facial challenge because the board has no discretion in the procedure that it applies to different licensees. Everybody gets the same procedure under 63-170. So the board didn't apply the statute differently to Dr. Reach as it would to anybody else. So the as-applied challenge is really a facial challenge wrapped up as an as-applied challenge.
So it didn't apply the statute differently to Dr. Rubin?
No, Your Honor. Oh, sorry, Dr. Rudin or Dr. Reach? I didn't hear you.
Dr. Rudin.
Your Honor, Dr. Rudin was convicted of a healthcare fraud violation.
But it involved controlled substances, right?
The conviction itself did not, though. It was about making misrepresentations and false statements.
So who gets to decide whether it involves, so the statute reads, a healthcare prescriber is convicted of a federal or state criminal offense that involves a controlled substance violation. Who gets to decide if it involves a controlled substance violation, and how is that decided?
The board would decide that, Your Honor.
But how do they decide?
They look at the elements of the offense included in the criminal statute, essentially. They don't look behind the elements to the underlying facts.
So simple possession of marijuana. If a doctor is convicted of an A misdemeanor, simple possession of marijuana in the state of Tennessee, the Board of Medical Examiners has to revoke their medical license.
Without looking at the statute, I can't say for 100% with 100% certainty, but yes, assuming it's a controlled substance offense, then yes.
Well, I mean, marijuana is a Schedule 6 controlled substance. Simple possession, the two elements are that you possessed marijuana, a Schedule 6 controlled substance. So that would result in automatic revocation.
Likely it would, yes, Your Honor.
Okay.
So turning to the facial due process challenge, first of all, a facial challenge is the hardest challenge to mount. The statute enjoys a strong presumption of constitutionality. It's a democratically enacted law. It's presumed constitutional, and that presumption applies with even greater force to a facial challenge. And as Mr. Gideon mentioned, the test for evaluating due process is the Matthews balancing test. And I'll just focus on the risk of erroneous deprivation factor, which it seems to be the one that is at issue between the parties. It's the board's position that the statute provides due process and the risk of erroneous deprivation is low because the licensee receives due process inside the criminal case. Revocation is only triggered upon a conviction. So that means the licensee has an opportunity to contest the charges against them in the criminal case. Revocation follows largely automatically from that conviction. The board doesn't find any new facts. So the risk is low. And the cases that the board cites in its briefing show this. There's no binding precedent directly on point that I could find, but courts in other jurisdictions have applied the erroneous deprivation factor to similar situations and have found that the risk is low. So to cite one example, Dixon versus Love, the United States Supreme Court case, where an individual was convicted of 3 separate traffic offenses, and that triggered automatic revocation. The Supreme Court said that the risk of erroneous deprivation is not great, where driver's license revocation was largely automatic and based on previously adjudicated traffic offenses. And there's other cases we cite in our brief as well, where a license is disciplined as a result of a criminal conviction without having a whole new hearing on whether the person in fact committed that crime. And the value of additional procedures is also low because the criminal court has already adjudicated the matter. And so there's nothing else to prove at that point. Once the criminal court has adjudicated the matter, the board is simply applying res judicata. It's recognizing the fact of the criminal conviction and then revoking based solely on that fact of that conviction. So the risk of erroneous deprivation is low, and so those factors in the Matthews balancing test support the constitutionality of the statute. And now I want to just turn to a few things in response to what Mr. Gideon said. Most importantly, I would say that this is the first time he has challenged the applicability of the statute to his criminal conviction. He has admitted that his crime involved controlled substances. In paragraph 5 of his statement of material facts, he says, On March 29th, 2023, Dr. Reach pled guilty to 3 misdemeanors related to prescriptions for Schedule II and Schedule IV controlled substances. So he admits in the statement of material facts that his conviction is related to controlled substances. He has not challenged in any of his briefing the applicability of the statute to his crime by trying to argue that it's not a controlled substance offense. Today is the first day he's made that argument. And as far as the vagueness issue is concerned, Judge Neal, you're correct to point out that a plaintiff only has standing to challenge vagueness insofar as it is vague applied to him. So all these litany of crimes that he mentions that could potentially trigger revocation, he has no standing to challenge the statute on that basis. The only standing he would have is with regard to his claim or his conviction. And one more thing I will point out, Mr. Gideon claimed that the revocation is permanent. The statute doesn't say that. The statute simply says that the licensee is to be revoked. The Board of Medical Examiners distinguishes in its regulations between revocation and permanent revocation. And the order that it put down on revoking Dr. Reach's license simply says revocation, which would entitle Dr. Reach to apply for reinstatement 1 year after the revocation was issued. The statute just doesn't distinguish between permanent and revocation, so the board interprets it as just a revocation, not a permanent revocation. If there are no further questions from the court.
Got some questions, Mr. Gallagher. Why was Dr. Yang's license not revoked?
Dr. Yang's license was not revoked because he was convicted before the enactment of 63-1170.
And so if he was convicted after the enactment, his license would have been summarily revoked as well?
Yes, assuming his conviction involved a controlled substance offense, yes.
Well, I mean, I think that's kind of the rub, isn't it? Is what is a controlled substance offense? So by the name of the statute that he was convicted of, would his license have been revoked?
I don't recall the exact statute he was convicted of, but I believe it was related to controlled substances. Yes, it was misprescribing oxycodone. So yes, he would have been revoked most likely.
And so even though in the facts with Dr. Rudin in the agreed order, all of the underlying activity had to do with controlled substances, because he pled to a statute that doesn't necessarily involve controlled substances, it doesn't apply.
That is correct, Your Honor. He pled guilty to a healthcare fraud statute.
So if he was charged with healthcare fraud and a controlled substance violation, and he's got a crafty defense lawyer that gets the state to dismiss the controlled substances action as long as he pleads to the healthcare fraud action, it's all based on the same set of facts. He gets to keep his license just because his defense lawyer did a good job.
That is essentially correct, Your Honor. Yes, the board is looking at the statute under which the licensee is convicted, not the underlying facts.
Okay.
Do you have anything else, Mr. Gallagher?
No, Your Honor, I do not. I would just conclude by asking the court to grant the board's motion for summary judgment and uphold the constitutionality of the statute. Thank you.
Thank you.
I have a question, Chancellor Rambo, for
Oh,
Mr.
proceed.
Gallagher, if it's okay? Sure. Mr. Gallagher, at the beginning of your talk, you talked about 7 other claims you allege are not before the court. Of course, they're not included in the petition. You named some paragraph numbers, and I just wasn't fast enough in my writing. Could you tell me those paragraph numbers again, please, sir?
Yes, Your Honor. So what I'm referring to is pages 3 and 4 in the memorandum of summary judgment from Dr. Reach. And the claims that are not in the petition are number 1 and 2, which are substantive due process claims. And then number 8, which is a unsupported by evidence claim, that is not in the petition. And also number 9, which is the vagueness challenge, is not in the petition.
Thank you very much.
And then I'll just mention that the other claims, 5, 6, 7, and 8, 8 double dips, but 5, 6, 7, and 8 are all under the UAPA Judicial Review Statute 45322. So those are also not before the court. The claims that are before the court are 3 and 4, which are the procedural due process challenge.
Thank you.
Anything else, judges?
No,
Mr.
thanks.
Gideon?
Yes, sir. 3 points to use my remaining time. Number one, I want to show you the petition, paragraph 8 of the petition itself. I respectfully disagree with the statements that counsel for the state has made about what was claimed and what wasn't. I'm not going to use the time to read it to you, but I respectfully request that the members of the panel look at paragraph 8, and subsection A does not limit itself to procedural due process at all. Number 2, the reference to TCA 4-5-322 is important. I suspect the members of the panel have had prior experience with administrative law, but this is another Tennessee statute that we believed to apply. It refers to a contested case, and it says that any person aggrieved by a final decision shall pursue relief, judicial review under that statute, and it says this shall be the only available method of judicial review, end quote. So that's why we initially proceeded under 4-5-322, because the statute says it is the exclusive means of review. But there is an important case, and that is Armstrong versus Tennessee Department of Veterans Affairs, 959 Southwestern 2nd, 595 at page 596, that says judicial review under this statute is meaningless if avoided by refusing to hold a contested case hearing, which is exactly what they did in this case. The last thing I would like to respectfully request of the panel members is for you not to assume, for the purposes of your decision, Mr. Gallagher's representations that the Board of Medical Examiners has any input at all in any decisions under this statute. That is not established by an affidavit of the current or former board members. And I submit if they were asked, they would say, we have no authority to take any action or provide any input at all. We respectfully request that this statute should be stricken, shut down, and that Tom Reed should have his license restored. Thank you.
Thank you. Any more questions from the panel?
No, thank you.
All right. This concludes the summary judgment hearing, and we'll ask the panel judges to stick around a few minutes on the private areas for us to discuss the case. Otherwise, court's adjourned. Thank you.
Thank you.